Imina 34 de legislador in Guahan is back in session. Mr. Majority Leader.
Thank you, Mr. Speaker. Mr. Speaker, notwithstanding the House rules, I move to go to item 18, the consideration of the daily file, third reading file, to act on Bill number 157-34 COR as amended by the Committee on Appropriations and Adjudication, and further amended in the Committee of the Whole, and Bill number 139-34 COR as amended in the Committee of the Whole.
Any objection? Hearing none. Clerks, please read the title.
Bill number 157-34 COR, as amended by the Committee on Appropriations and Adjudication, and further amended in the Committee of the Whole, introduced by Frank B. Ugin Jr., Joe S. San Augustine, James V. Espadon, William M. Castro, an act to repeal and reenact Article 2 of Chapter 10, Title 12, Guam Code Annotated, relative to authorizing the Jose D. Leon Guerrero Commercial Port to issue revenue bonds and other indebtedness for the purpose of financing or refinancing improvements and or working capital relating to the Jose D. Leon Guerrero Commercial Port and other related facilities and operations of the Jose D. Leon Guerrero Commercial Port, and approving the terms and conditions of the issuance of one or more series of such bonds pursuant to such article for such purposes.
Roll call.
Senator Atta. Senator Atta, aye. Senator Ugin. Senator Ugin, aye. Senator Castro. Senator Castro, aye. Speaker Cruz. Speaker Cruz, nay. Senator Espadon. Senator Espadon, aye. Senator Esteves. Senator Esteves, aye. Senator Lee. Senator Lee excused. Senator Morrison. Senator Morrison, aye. Senator Muñoz. Senator Muñoz, aye. Senator Nelson. Senator Nelson, aye. Senator Rodriguez. Senator Rodriguez, aye. Senator San Augustine. Senator San Augustine, aye. Senator San Nicolas. Senator San Nicolas, nay. Vice Speaker Terlahi. Vice Speaker Terlahi, aye. Senator Torres. Senator Torres, aye.
On Bill 157-34 COR, the votes are 11 ayes, 3 nays, 1 excused absence. Bill 157-34 COR has been duly passed by the body. Bill 139.
Bill
Roll
number
call.
139-34 COR, as amended in the Committee of the Whole, introduced by Talina C. Nelson, William M. Castro, Fernando B. Esteves, an act to approve the terms and conditions of Guam Power Authority revenue bonds to refund outstanding Guam Power Authority revenue bonds.
Roll call.
Senator Ada. Senator Ada, aye. Senator Uggan. Senator Uggan, aye. Senator Castro. Senator Castro, aye. Speaker Cruz.
Aye.
Speaker Cruz, aye. Senator Espadon. Senator Espadon, aye. Senator Esteves. Senator Esteves, aye. Senator Lee. Senator Lee excused. Senator Morrison. Senator Morrison, aye. Senator Muña. Senator Muña, aye. Senator Nelson. Senator Nelson, aye. Senator Rodriguez. Senator Rodriguez, aye. Senator San Augustine. Senator San Augustine, aye. Senator San Nicolas. Senator San Nicolas, aye. Vice Speaker Talahi. Vice Speaker Talahi, aye. Senator Torres. Senator Torres, aye.
Bill 139-34 COR received 14 ayes, 1 excused absence. Bill 139-34 has been duly passed by this Guam Legislature. Thank you. Mr. Majority Leader.
Thank you, Mr. Speaker. Notwithstanding the House rules, I move to go back to the second reading file.
Any objection? Hearing none. We're back in second reading. The first item on the agenda for this morning is Bill 45. Senator San Augustine, you're recognized.
Mr. Speaker, I move to place Bill 45-34 COR as corrected by the prime sponsor, amended by the Committee on General Government Operation and Federal, Foreign, and Regional Affairs, and substituted and further amended on the floor, and further amended by the Committee on General Government Operation and Federal and Foreign and Regional Affairs. On the third reading file, I'd like to discuss it.
Any objection? Hearing none, you're recognized, Senator.
Mr. Speaker, this bill is designed to reform the election process to make it easier for new candidates to run for office. This is the first step in making our government more responsive to the people. The current primary process is designed to minimize competition against the political parties. This bill will encourage more people from all walks of life to run for elective office. This bill also corrects a financial wrong. As it is set up now, the purpose of the primary election is to select candidates to represent the Republican and Democratic parties. That is the function of the parties and not a function that should be paid for by taxpayers. This bill will make the legislature more democratic. I have heard some concerns that without the primary, allowing anyone to run the general that can get signatures on a ballot, the election will turn into a free-for-all. More competition will just require candidates for office to work harder to get elected. There has been concerns about the Organic Act, about having a runoff election. The Organic Act only requires a majority of votes for office of governor and Washington delegate. A majority has three definitions. One, the largest number. The other, 50% plus one. And the third is specific numbers such as 2/3 or 80%. You know, I've mentioned in the past that I presented the Governor Gutierrez's election was contested by then Governor Atta, and it was brought up that the Supreme Court ruled that he won because of the majority votes, even though the Guam Election Commission first declared him as the winner with 50+1. When it went to court, the Supreme Court did not rule in favor of the Guam elections, identifying them as 50+1, but that they had the majority votes cast. Mr. Speaker, I have one amendment to this bill. It's being addressed because of the letter from the Guam Election Commission, and I have it. It's being passed out now. If we can take 1 minute to get it around.
You can speak on it. Go ahead.
Okay. The amendment is referring, beginning on line 27 on page 15, is to strike out after, when it reads on the sentence, to vote in Guam and must be filed with the Commission no later than, to strike out the first Monday after and before the primary election, and to add on, at the end where it says special elections, add on 60 days before a general election, no defect in nominating petition presented. This amendment was proffered because of the most recent letter from the Election Commission.
Has everybody had a chance? Has everybody had a chance to review the amendment? And would anybody like to speak on the amendment? Well, we'll take a short recess and allow everybody to read. Back in order. On the amendment, any senator wish to be heard? On the Snogestein amendment on page 15, any senator wish to be heard? On the amendment? Hearing none, is there an objection to the amendment? Seeing or hearing no objection? On the main motion, Senator? Do you have anything further?
I have nothing else further.
Okay. On the main motion, Bill 45, as has been presented to us this morning, does any senator wish to be heard? Senator Torres. Senator Torres, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, Bill number 45-34 certainly has gone through a lot of rewrites and edits from what it was originally presented. And rightly so, because when it was presented, it was so convoluted that it was hard to gauge whether we were dealing with one bill or four bills. So it's good that we narrowed it down to more or less the version that we have now, which is essentially just removing the primary election from the Guam Election Code. I do not stand in favor of this bill. I think that all good intentions of wanting to encourage greater participation, greater incentive for people to participate, theoretically to save money, those are all good intentions and all good reasons to pursue legislation. But I don't think that Bill 45 accomplishes that. And I want to address one specific bone of contention or an area where there's some disagreement. And that is whether abolishing a primary election would result in a runoff gubernatorial election, thereby negating any cost savings achieved by eliminating the primary. The Organic Act of Guam requires that a governor be elected by a majority of the votes cast, and that if no candidate receives a majority, then a runoff is required between the two candidates with the largest number of votes. I took note of what the proffer of this bill was asserting about the definition of majority. But within the context of election law, it is a broadly accepted principle that a majority refers to more than half of a total or a group of more than 50%. In Black's Law Dictionary, majority stands in contrast to plurality, which simply refers to the greatest number of votes. There is some concern that I have that in abolishing the current primary election system without replacing it would in fact allow for an undefined number of candidates to run for governor of Guam. However, abolishing the primary would not eliminate the majority requirement imposed by the Organic Act. So regardless of whether there is a primary, a gubernatorial candidate must be elected by more than half of the votes cast for governor in the general election. Will somehow always end up with the 50% one rule. And abolishing the primary would not necessarily increase the number of candidates in each election. I mean, it is theoretically possible that a limited number of candidates would run with or without a primary. And it seems likely over the long run that we can see an increase in the average number of candidates. But any increase in candidates will result in some degree in vote splitting, and each candidate's probability of achieving more than the 50% of the votes would be diminished, thus increasing the likelihood of a runoff election. So I do not believe that Bill 45-34 is a good measure. I don't think that it necessarily will very easily encourage people to run and not result in a problem of achieving a majority of the votes, which, again, is very clearly defined in an election law. And so I don't stand in support of this bill. I think that it stands the chance of causing more harm than good, although well-intended in its introduction. But ultimately, abolishing a primary election, although it will not necessarily result in a runoff gubernatorial election, it will increase the probability and negate any initial cost savings achieved by eliminating the primary. And right now we know that to run for office, there's very little that's required of a candidate or a potential candidate. There's a residency requirement, there is a citizenship requirement, and there's an age requirement. But outside of that, that's really all that is required of anybody to step forward. So the bigger question is, what is it that's going to take people to stand up and present themselves as candidates? That's really an open-ended question. What motivates people to step up to public service? And I think it's a lot broader and a lot more far-reaching than simply eliminating the primary election. I think that's a very simplistic approach to the question, and I don't think that the results are clear. But surely the risk of not achieving a majority of the votes, particularly for the gubernatorial election, cannot be circumvented by introducing this measure. Thank you.
Thank you, Senator. Any other senator on the main motion, Bill 45? Any other senator on the main motion, Bill 45? Vice Speaker, you're recognized.
I would just like to ask the sponsor if he would yield to the question of if, as the Election Commission points out, this may result in the need for a runoff, if he could remind us when that runoff would occur. I guess my concern is that I don't have it in front of me, but I thought, just from recollection, that a runoff would not let us know who the next governor would be until January. And I want to know if that's correct, or how soon could we do a runoff after, if the general election date is still held in November, when would we know the governor if we had to do a runoff?
Do you yield, Senator?
Mr. Speaker, I'm not too sure what she said. I could barely hear back here, but if she's asking when the runoff would happen, by statute, if there was going to be a runoff, it'd be within 2 weeks. But, you know, Mr. Speaker and my colleagues, if you look at the letter that was sent to all the members, dated November 29, from the Election Commission, as the good Senator Torres mentioned, the common use of majority was 50+1. If you look at the code they cite, it was referring to referendum, initiative, everything else, but the election of candidates. It never talked about candidates, always said about majority. And if you follow the definition that she mentioned, plurality, that's the bottom line. Now, if the Election Commission would use the plurality on the results, we would have went to court on the Gutierrez and Ada case, and that would have been easily resolved, just based on that definition. It was the majority votes, and the Supreme Court ruled that. And just knowing recently the ruling from the Guam Supreme Court, majority is the most votes cast. Thank you.
Vice Speaker?
Could we please have a 1-minute recess, Mr. Speaker?
Yes.
If what he says is correct, yeah, that's
Short
different
recess.
than what the Election Commission is saying. I'd like to just verify.
Vice Speaker, you're recognized.
Sorry, I'm just concerned, Mr. Speaker, that what's being represented might be correct, but it's not consistent with what the Guam Election Commission wrote to us recently after we sent this bill back to committee. And so the difference is they are saying that majority, the Guam Election Commission says majority will then mean 50% plus 1 of the total votes cast for that election. But the sponsor of the bill is seeming to say that it only requires a majority, and majority does not mean 50% plus 1. It just means the most votes out of the rest, which I think we use the word plurality in the code when we talk about that. I guess my other concern is that I had thought that if we had a runoff after the general, which is held in November, that we wouldn't know our governor, given the current procedures for the general election. We have to send ballots off island and we wait for those to come back. But I see in the Organic Act a provision that says on the 14th day, if no candidates receive a majority of the votes cast in any election, on the 14th day thereafter, a runoff election shall be held between the candidates for governor and lieutenant governor. So I don't know how we're going to, maybe they're just going, I'm just guessing, but I think Election Commission would have to wait then to certify the election until after the off-island votes come in. I don't know how long that takes. I'm guessing 30 days, but all right, I guess I'm just concerned about that. If this bill talks about, I mean, if it's true what the election says, that this will more than likely result in the need for a runoff in the gubernatorial campaign, then I think we need to spell that out very clearly in our code, how these runoffs are going to occur, so that we will all know going forward how those close races will be decided, or how soon they will be decided. Thank you, Mr. Chair.
Thank you. Any other senator wish to be heard on the main motion? Senator Estevez.
Thank you, Mr. Speaker. I concur with what the retiring speaker was saying. I think there's a couple of differences when as I'm understanding and reading both what was put out by the Supreme Court and my interpretations or my readings of the Organic Act with regards to majority, it can't be applied to every single election. So for example, senators are a body of 15. A plurality vote can work. But when you're talking about a single office, a singular office where there is only one, the plurality vote eventually has to lead to the 50+1 rule. Unless what we're saying based on this current piece of legislation is if we're fine with the Magalahan, the governor of Guam, being elected into office out of an exponential amount of candidates with 8,000 votes, 5,000 votes, 2,000 votes, whatever watered down number we accept. And that's why it's imperative that the 50+1 standard applies to this. Now, if that's the case, depending on the situation and how watered down the vote can get, if we are deciding that we want the governor, chief executive of the island to be voted by a true majority of the population of 50+1, and not by 2,000 votes, not by 100 votes, then we're going to have multiple runoff elections until that pool dwindles down and until only one team wins out. And so I echo the concerns with regards to, as we're making current changes and with election reform, it doesn't specify enough in detail how runoff elections are going to be conducted and really towards what purpose. So if we're going to say that we're going to just completely accept the plurality vote, then we really need to understand that the people of Guam are ready to accept the governor of Guam winning with less than 10,000 votes among the votes cast. So again, I think there still is a lot of work to be done here, Mr. Speaker, and while I applaud the author of the bill for the inventiveness and the thought and all the good intentions with it, at this time, I can't support this piece of legislation. Thank you, Mr. Speaker.
Thank you, Senator. On the main motion, any other senator wish to be heard? If not, the sponsor is welcome to close. Oh, wait. Senator Baldon.
Thank you, Mr. Speaker. Mr. Speaker, in the prior session, when this bill first came up, I spoke to the interpretation of the Supreme Court in the case of Ada versus Gutierrez, and that decision, right, I don't think really spelled out very clearly any reasoning that supports what the sponsor of this bill said earlier. I think it's still a gray area. What is the definition of majority? As the sponsor of the bill said just a few minutes ago, majority has 3 definitions. Those definitions were really never reached by the Supreme Court in general. They reached a decision, and their reason was based on the facts that were presented, and really the argument at the time was that the Ada team was basically saying that nobody got the majority because within the facts of that case, included in the total number of votes was also all the votes cast plus the blank ballots. And the Supreme Court, what they did in that case is then decided that according to our Organic Act, it has to be decided by all the votes cast in that specific election minus the absentee, or not the absentee vote, the blank ballots. And that's how they got to the 50% plus 1. That being said, going forward, it's still not clear in this legislation what it would take, and whether it's even consistent with the Organic Act. And I think that's where we run into the concern that if we pass this legislation, it would still be contested in a court of law, I would imagine, to really come to the determination of what constitutes a majority, because there are differing opinions. I myself believe that the majority is 50% plus 1, according to the way that the Organic Act reads, which basically says the majority of all votes cast. For example, if 50,000 votes were cast, the majority of the number of that vote of that number would be 25,000 plus 1. That would be the majority of that total number of the votes cast on that election. Of course, there are those who have differing opinions, but that's precisely the point that I'm trying to make. Because there is a difference in opinions of what the majority means, that then becomes the issue and the topic that would then have to be addressed in court. So that is not specifically spelled out here. Another issue that was brought up of why this legislation is good, and I agreed, and in fact I even spoke to it in the last session, is that it does allow more candidates to run. If there's no election, everybody proceeds on to the general election. And I think that's a good thing. However, several legislatures ago, several terms ago, there was an effort made by our former colleague, Senator Chris Duenas, to try to get the same results in allowing more people to advance to the general election to get in. And his approach was to make it easier for independent candidates to go directly to the general election. And it seems to make sense, because if they're independent candidates and don't belong to a party, then there's no need to run in a primary. And that was the premise of his approach back then, that if you're not a party, if you're not affiliated with the Democratic Party or the Republican Party, and you claim yourself as an independent, then there is no need for a primary runoff because you don't belong to either of the parties. I think that might be perhaps a more fathomable approach, that those who don't want to go through a primary election because they belong to neither of the parties, then they should be able to go on as an independent candidate all the way to the general. The primary election is, again, for the parties to be able to select their candidates. And whether it's done with government assistance in terms of funding or whether it's not, that's really what it is, right? It's for the parties to elect their candidates to go on to the general election, right? So I think in total, and again, we can go on, but I think there's still a lot of questions that need to be answered and a lot of issues that need to be scrutinized before we can pass on this type of election reform. And I don't think we've done that just yet. So as much as I admire the fortitude of the sponsor in pushing this forward, I have a hard time supporting this bill at that time. I believe in the end it will cost us more money, and it may even delay the transfer of power from one administration to a new administration, and may also convolute the race for the congressional office in D.C. So until a lot of the issues are ironed out, and until we come to a firmer definition consistent with the Organic Act of what constitutes a majority of the votes cast, it would be hard to accept this legislation and pass it into law. That's my personal opinion. Thank you, Mr. Speaker.
Thank you very much. On the main motion, I see Senator Torres, your hand has gone up again. If no one else has anything, I'll recognize Senator Torres.
Thank you, Mr. Speaker. I just wanted to add to the discussion about the differences between majority and plurality. And while the retiring speaker spoke about a specific case, a challenge, Gutierrez v. Ada, there was one case in Guam politics that addressed the issue where there was a distinction between majority and plurality. And that was a case, a Ninth Circuit case, Jose v. Mesa, involving Jose v. Mesa, where he challenged the results of a primary election. And in that case, the plaintiff argued that the Guam primary was inorganic because it allowed two vote-getters to be nominated by a plurality instead of a majority. Now, the Ninth Circuit, agreed that the Organic Act required a majority, but of course the issue there was the primary elections, which, where I'm getting at here is that the court affirmed the district court's ruling that the Organic Act majority requirement was applicable only to general elections. And although it wasn't asked to rule on the definition of a majority versus plurality, its ruling did acknowledge the distinction between the two terms. And differentiating between the two, the court held that the Organic Act requires a majority to prevail in a gubernatorial general election. And I also wanted to point out that in various other sections of Guam Code Annotated 3 GCA, there is a distinction that is made, and it's relevant because if, in looking at the constructs of statutory interpretation, where you look at something as a whole, and where they the legislature purposefully selected contrasting terms when they drafted and enacted our election laws, that was done to distinguish the two. That there was clearly, where it used plurality, it was referring to the greater number of, and where it dealt with majority, it was dealing with or referring to a broadly accepted principle in election law that a majority refers to more than half of a total or a group of more than 50%. So I just want to point out that there was in fact case law that drew the distinctions between plurality and majority, and you know, there's no disputing that because the two are contained in various places, that it is intentional that there is a distinction between one or the other. And so I just wanted to re-emphasize that. Thank you, Mr. Speaker.
Thank you very much, Senator. Any other senator wish to be heard? If not, the sponsor is welcome to close.
Thank you, Mr. Speaker. My colleagues, I have only asked that you pass this law to make the election process a lot easier. Number two, you all agree that the primary election is a party election, and the party should step up and do their part. And the people of Guam shouldn't be paying for what they should be doing. And that was the main thrust of this bill. For the government, and if we want to talk about saving money, we take a look at everything else that's going on in the government. But this is one step in that direction. Thank you, Mr. Speaker.
Thank you very much, Senator. On the motion to send the bill down to the voting file, any objection? Hearing none. Next bill on the agenda, 164. Senator, you're recognized.
Mr. Speaker, I move to place Bill number 164-34 LS, an act to add a new section 2120 to Chapter 2, Title 19 of the Guam Code, annotated relative to protection against discrimination on the basis of sex, gender identification, and gender expression. And that it be moved to the third reading file. I would like to discuss.
Any objection? Hearing none.
Mr. Speaker, my colleagues, Bill 164-34 will clarify existing public law to prohibit discrimination on the basis of sex, gender identification, and gender expression. Transgender people have faced discrimination every day. According to the National Transgender Discrimination Survey, 26% of trans people lose a job due to bias. 50% were harassed on the job. 20% were evicted or denied housing. And 78% of the trans students were harassed or assaulted. These numbers may differ here on Guam, but that doesn't change the fact that the public needs to update and be inclusive of all Guam people. I believe that our community deserves equal access to safe and welcoming public and government venues, and are owed the respect and equality on the basis of humanity and dignity regardless of gender, identity, and gender expression. This transgender inclusive bill is an important step in ensuring equal rights for all citizens of Guam.
Thank you. On the main motion? On the main motion, any senator wish to be heard? Vice Speaker?
Thank you, Mr. Speaker. I want to rise in support of the bill and thank the sponsor for this bill. We heard, when we had the public hearing on this bill, or the committee heard testimony that that here on Guam and even nationally, they feel a lack of support, some violence, harassment, and other negative experiences that people feel based on, because of discrimination. And I know that this bill will not immediately remove all discrimination, but I do hope that it would be a step showing the support of the people of Guam and the government of Guam, and a step in urging all facets of the government of Guam to implement whatever is necessary to ensure that that there is no discrimination in this regard. And again, I thank the sponsor for this much needed bill.
Thank you, Senator Nelson. You're recognized.
Mr. Speaker, I have a question for the sponsor of this bill.
Please pose your question.
On page 2, line 13,
It says, prohibition against discrimination on the basis of sex, gender identification, and gender expression. All persons within the jurisdiction of Guam, no matter what their sex, gender identification, or gender expression, are entitled to the full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of every kind whatsoever and in all government agencies. My question to the sponsor of this bill, Mr. Speaker, is what does that define? This is a very broad stroke of definition, so give us something concrete that this section is saying, a concrete example of what this section is saying, that all facilities, privileges, accommodations, advantages, services in all business establishments of every kind whatsoever and in all government agencies.
Do you yield?
Mr. Speaker, I would believe that the good senator is referring to, I guess, the restroom facilities. Because I'm trying to, maybe I can ask her, if that's what you're referring to.
I'm not referring, I'm asking what is the intent of this piece of legislation on page 2, line 13 through 18.
From 13 to 18, very specific. All persons in the jurisdiction, no matter what their sex, are be entitled to the full and equal accommodation of whatever is out there, regardless of your gender or your gender expression. You might want to follow that up with another question there, Senator, so I can be more specific. Because if it's
yes,
it's about—
Yes, that's the question. My question, Mr. Speaker, to the sponsor of this bill is, give us something specific.
I don't understand. It's everything.
We'll take a short break.
Thank you, Mr. Speaker.
We're back on the record. Senator Nelson has posed a question, and if you wish to respond or can respond, Senator Augustine,
Yes.
please.
Mr. Speaker, looking at that page 2, 13 to 18, when it talks about full and equal accommodation, whatever you offer to someone that's not transgender, you have to offer to a transgender person. That's what it comes down to. When you want to talk about the advantages, I think I don't know if it does exist on Guam. If there's a special discount for just males or just females, and somebody walks in there and happens to be a male and dresses as a female, and there's a female discount, it's like a ladies' drink, you got to offer that to the person that's dressed like a lady. Should be entitled to that same advantage. Moving along, facilities, privileges, or services in all business establishment. Whatever is given to someone that's not a transgender, it should be afforded to a transgender. That's what it comes down to. And this only talks about the government. It's not talking about the churches or anything. This is specifically in the public, in the government, and in the government. I hope I answered that question. Maybe not sufficient, but I hope I did.
Okay, thank you, Senator Nelson. Is that sufficient?
No, it is not, Mr. Speaker. The sponsor of the amendment also mentioned facilities. Can you give us a more concrete example? Not for me, but for the people that are watching to see, so that they understand the impact of this bill.
The question was, can you give an example of what you mean by facilities?
I would assume facilities is anything in general that you would allow, such as if we want to talk about restrooms, you have the male and you have the female. The transgender walks in, or the person's dressed as he's a male, he's dressed as a female, and he wants to go to the, that there's a lot of gray areas in that area when it comes to the restroom, and a lot of the establishments are already set up in that form, where they have one restroom, both male and female can take turns using it, and they can continue to do that practice at all the other restaurants or any other place. So that is one facility. Gosh, everywhere else I've seen, they allow both male and female to go to all these facilities, and they have shun transgenders from going in there, even though they were entitled to. Now this allows them to go in there and be protected by law.
Thank you. Senator Nelson, you still have the floor.
Thank you, Mr. Speaker. I do have another question for the sponsor of this bill. Declaration of Purpose, page 2, line 1. Although protection against discrimination of persons on the basis of sex is well established and guaranteed by the laws of the United States, the laws of Guam, and court interpretations of those laws, the definition of what is included in sex is not well established by court decisions. In order to clarify that all persons are due the protection against discrimination, both in government and public places, this section is enacted to specify that the protection against discrimination includes discrimination based on sex, gender identity, and gender expression. Can the sponsor of the amendment explain, or perhaps is he aware of this definition of sex and that has been challenged in the courts?
Senator Augustine?
The question is, am I aware that it's being challenged?
If there's any cases that have been challenged in the courts.
Because it states here, a part of the bill, Mr. Speaker, it mentions it, so if you can give us an example.
anything being challenged about sex. I know the discrimination in the United States was challenged, and that's why they came up with relieving them of the discrimination of transgender. So, what?
Yes, but he mentions this in the bill. So for the people to listen that are watching, because it's mentioned in the bill, it's very germane. What are some examples of these court interpretations of these laws?
Do you wish to continue to yield? Do you yield? That's his answer.
Can we get a recess, Mr. Speaker, so we can get an answer?
I'm not sure. He has answered, and that's the extent of the yield. And so, if you have any issues,
so he does not wish to yield to that question that I posed.
He answered. You may not be satisfied, but that was his answer.
Okay, then that answer, thank you, Mr. Speaker, is definitely not satisfactory, because in this section, page 2, lines 1 through 8, or more specifically, line 4 of the bill, it talks about established court decisions. And if we can have examples for the people to see that are watching what these court decisions are, because he is the sponsor of this bill, then it is good to know these court decisions. And so, Mr. Speaker, I'm looking at this bill. And some of the reasons, first, we cannot even get an example from the sponsor of the amendment of court decisions. And this is very important, because we pass legislation a lot of the times looking at current and previous laws. And so if this is not clearly defined, if the sponsor of the amendment cannot proffer these concrete examples, these concrete court cases, then there's a lack of wisdom in this piece of the bill, especially if it's on the sponsor. The next one that I asked was, or actually was the very first question, the prohibition against discrimination. Now, the reason or the examples that was given to us was to offer discounts at a bar. If it's ladies' night and you're dressed up as a lady, you get the discount of ladies' night. If you're a man and if you're a woman and you're dressed up as a man, and if it's, I don't know, male night, you get a discount as a man. And then the interpretation of facilities was restrooms. And the sponsor of this bill said that he sees it already, that the unisex bathrooms are already in place, and this is not going to have an impact on the businesses, which is absolutely false. Because unisex bathrooms are not in place everywhere, and it's not what is the word? It's not even pushed out as a majority. It's very few places have unisex bathrooms. And it's the reason why it is because the businesses look to save money because of the space that they rented. So now we're imposing additional weight on our local businesses to make accommodations for now you have to transition into a unisex bathroom. Or we can do this. I can go to Guam Premium Outlet. I can go to the mall. I can go to a Agana shopping center. And I take my 3-year-old godson into the restroom because he needs the restroom and he cannot go into the male restroom. And children are wise. Sometimes they make more sense than us adults. And their questions are very succinct and very innocent. I take my godson in there, and he sees a man dressed up as a woman. And I'm not speaking this out of an example because this has happened. And he's, you know, he's wondering, he's inquisitive. We wash our hands, we leave. And he says, Nina, who was that? And I ask him, who? The lady, who is that? Who is that? Do you know that person? I said, no. And he looks at me with a confused look. And so I want to, the sponsor of this bill cannot even answer some of these very fundamental questions of this bill. And I want to ask my colleagues, you know, to really consider this. I want to also make it very clear that I am not against, most definitely not against, and no judgment towards our transgender people. Absolutely not. Absolutely not. It's not about that. It's about the implications that is going to happen with the children. Society, we are seeing a trend that we must accept everything in the guise of tolerance. But we never look at the deeper issue. We never look at the impact that it does to the individual holistically. Because you don't go with this idea, you are prejudiced against that. Because you don't go with this idea, you are wrong about this, you have no compassion. You don't understand my suffering. You don't understand the bullying that I had to deal with. And this is not the case. I, as an individual, understand that suffering. It's in my family. It's in my history. But this, we need to caution. Because what this does just not only impacts the discrimination of a select few, it impacts the children. It sends a message to our children. And our children today, there's so much confusion. There's so many questions. And because no one can answer their questions, or they don't have a clear understanding of what it is, and they see what society does, and they see what's going on in the news. And because perhaps it's popular, or they feel it in themselves, they say, okay, this is me, and that's it. We need to do something more. What about discrimination against the homeless? We look at the homeless and we walk the other way maybe. We don't go up to them and talk to them. We look at the homeless and perhaps sometimes we might judge. But it's good to see that we judge, because we are no better. So maybe it creates a conversion in us. It's important to meet the people down in their suffering. But if the proffer or the sponsor of this bill specifically stated in his opening speech, discrimination for all, this does not address discrimination for all. What about our Micronesian brothers and sisters? The recent acts that the governor has done with placing them back into their own islands because they committed a crime. if you listen to the public, created so much hate against our Micronesian brothers and sisters. So much prejudice. And just that one singular action fueled the division in our community. This one singular action that the sponsor of the bill could not even defend properly will create a mass confusion within our children. My colleagues, I humbly ask that you do not support this bill. Thank you, Mr. Speaker.
Thank you, Senator. Any other senator wish to be heard on the main motion? Senator Munya and then Senator Esteves.
Thank you, Mr. Speaker. I too, like the previous speaker, I don't disagree with the intention of this bill. I fully support equal rights to gender identification and gender expression. But the problem that I have, Mr. Speaker, is what she pointed out, the previous speaker pointed out in lines 13 through 18 on page 2, where it says, all persons within the jurisdiction of Guam, that means everybody, no matter what their sex, whether they're male or female, no matter what their gender identification, whether they choose to identify as a male or female, no matter what their gender expression is. So for me, that just says everybody across the board. And then the next line, it says, are entitled to the full and equal accommodations, advantages, facilities, privileges, or services. That means anything, which I just wanted to ask the author, does that mean then that his intention, if you really look at it, just take down the signs that say men and women, and anybody can just use any facility, any fitting room, any bathroom, anything. It just seems a little bit broad. And if he wanted to be more specific while trying to be politically correct, then maybe he should be more specific. Because right now, the way I read this, it just opens it up to everybody and anything. And I guess the question to the author would be, was that his intention to remove the men and women signs at any facility?
Do you yield to that question, Senator?
Mr. Speaker, if any of my colleagues want to introduce an amendment to the bill, they're welcome to. The bill was written and it was basically following the Hawaii Civil Rights Commission, and it followed that line of thought and what's going on in the nation today. But if any of my colleagues actually believe that you want to add an amendment to it, feel free, and we'll accept it and we move on. If you want to restrict it more, then we'll put the restriction, but basically it's to free up the discrimination of the transgender, okay? That's all it comes down to, and I welcome any of the amendments that you may have.
You still have the floor, Senator. Do you have...
I'm not sure, Mr. Speaker, if this would change the whole premise of the law or what he intended, but maybe to offer an amendment to strike out what their sex on line 15. So it would read, starting at line 14, all persons within the jurisdiction of Guam, no matter gender identification or gender expression. I'm not sure if that's something that we can explore.
On the Munya amendment, Senator San Augustine.
On our amendment to strike out the word sex, but keep the word gender identity, based on sex, I have no problem with that one because it still maintains the discrimination of gender identity and gender expression.
Let's take a short recess. We're back on. Senator Munoz, do you have anything further? Or?
Thank you, Mr. Speaker. I'd like to withdraw my amendment.
All right, thank you.
Yeah, okay.
Senator Estevez, you're up next.
Thank you, Mr. Chairman. I have to just echo some of the concerns about some of the definitions we see here. I think it's very important. We're asking for a culture change, at least the way I'm reading it. It's very, very general. And while I understand that this is just a law copied from another state, we have a responsibility to write policy that best fits Guam, that best fits our people, taking into consideration their thoughts and their feelings. But when I read this, I'm supportive of the idea, Mr. Chairman, or Mr. Speaker. I think it's a very important thing to ask. And when you break down all of this, what is the root thing we're asking? What is the root of this that we're asking not to discriminate against? And it's not necessarily about feelings. It's not necessarily about feeling comfortable. Those aren't rights. You do have a right to be safe. But I think the key and core right we're talking about here is the right for somebody else not to tell you what you are. Somebody else shouldn't tell somebody that, oh, well, you're dressed like a man, you're a man. You were born biologically as a man, so you're a man. And nobody has that right to tell anybody else that. That should be on the individual to make those determinations. But what I see are some, as we're looking at the definitions and we're actually talking about the policy here and the bills, some of the things we're talking about are a bit counterintuitive. Because as I read this, this doesn't only just affect the transgender community. It has far-reaching implications. And I have to think about the potential for the negative aspect because we know a few bad apples spoil the bunch. And I think it's a valid concern that I've heard from constituents. Well, what about the restroom facilities at Department of Education? If without any rules in place, without any input, without any cooperative work with the executive branch and the executive agencies, what we're going to do is one kid to just decide he's going to go into the female restroom at one of the public schools. The school aide, you know, has no authority to say you can't be in there because although the young man is dressed like a male, I can't tell him that he has no right to be in there. I can't discriminate or judge whether or not what he or she decides their gender identity is. And that's a valid scenario. That could actually happen. Because while it's a wonderful thing, Mr. Speaker, that we're getting away from us and the government really telling people who they are, what they're supposed to think. I think that's a beautiful thing. But there's a balance to that. Because when we put that back on the individual, this is based on an idea that everybody is responsible. And we know that is just not the case. That is the reality we live in. I think it is a great thing that we're moving to this, and I think that it's going to be a culture change. I think that adults are going to be responsible for this moving forward, and there will be some hiccups. But I think there definitely is a lot of merit to the argument that, is this something we want to establish in Department of Education? And I think we really need their input on some of these. Because as I read it, facilities are all facilities. And if we want to say and define that and narrow that scope or put some other amendments in here that may say, hey, you know, generate rules first, and then maybe we can look at applying a Department of Education so we're not opening up Guam to lawsuit. But furthermore, I think even getting the input from parents in the DOE community and seeing what they believe. And it's definitely not going to be an easy path forward. And as much as I support the initiative, the idea, the very core foundation of equal rights that this bill proposes, as a practical matter, there are too many unanswered questions. And just as a matter of construction, I read here on line 7 and line 8, sex, gender identity, and gender expression. Then when you go down to 13 to 18, again, and gender expression. Then when we go down to line 13, although they're separate items, we have a definition that applies for gender identity and gender expression as the same thing. So again, things just are not, it does not read well. Are we establishing that gender identity and gender expression is the same thing? Then why are we using an or on the line? And those are the type of definitions that when it comes to really the legal aspect and the huge change we're making in our government, I think we need to answer that. As I read business establishments, I'm reading everything. There's nothing, as I'm reading everything within the jurisdiction, I think this places an undue imposition on the church. Is the church supposed to follow this statute? Because it's not clear here as you read it. All business establishments. I think now we really have to have that discussion as well on the rights of the businesses. I don't believe that they should discriminate. But at the same time, if I'm operating a facility such as a hotel in Tumon, I'd like some input, and I think it's a very important question that what are the potential implications to our tourism market? If you kind of look at some of the numbers and you look at the Korean market, which is what's sustaining the economy right now, it's a family-oriented market. They come in large groups in their family. And we have to ask that question, and we should get input from the business owner. Do you think, in your experience and knowing that these families are they prepared to see this? Is this something that visitors to Guam want for their children? And those are all of the things that we need to weigh, because while it should not matter at all when it comes to discrimination, when it comes to telling somebody what it is they should identify as and discriminating on that matter, while that is the core of it, we cannot ignore the reality of everything that's connected with that. And as policymakers, Mr. Speaker, I think all of these different questions should be asked. And while I'm supportive, and I'll remain supportive of the intent and the initiative and the way forward, we still need to make sure we're applying our due diligence moving forward, and everybody has a voice in this, and we weigh everything. So at this time, Mr. Speaker, I'd like to make a motion that we send this bill back to committee.
A motion has been made to send the bill back to committee. Is there any objection? There's an objection. All those in favor of sending the bill back to committee, please indicate by raising your hand. Motion passes. The next item on the agenda, Senator Esteves, is your resolution.
Thank you, Mr. Chairman. I'd like to make a motion to move a substituted version of Resolution 242-34, or to be accepted. I motion for Resolution 242-34 to be accepted by this body as substituted.
On the motion to accept the substituted version of the resolution, is there any objection?
They're passing it out right now. Mr. Speaker, if I may just be indulged to explain the reason for the substitution.
Please proceed.
So specifically, as it's getting passed out to my colleagues, it primarily presents with grammatical corrections. So on line 13, the word administering is striked out, colonial is striked out and substituted with the word administering. Whereas line 13 now reads, the United States in its capacity as the administering power. The only other change is page 2, line 14. We placed a comma after the word source and removed the word what, which now reads, funding sources, comma, turns a long-awaited resolution.
Do you wish to speak on the motion? I mean, on the resolution?
Yes, Mr. Speaker, has it been accepted by this body?
Is there any objection to the accepting the version that's been distributed? Seeing none.
Thank you, Mr. Chairman, or Mr. Speaker. Resolution number 242-34, introduced by myself, my colleague Senator Nelson, and colleague Senator Castro, relative to requesting that Congresswoman Bordallo and members of Congress seek an alternative source of funding for war reparations due the people of Guam. Mr. Speaker, this resolution was passed by the Decolonization Commission as one of their core issues and was represented in one of the meetings. The information provided was provided and voted on by that body at my request in moving forward. And if I could just read a couple of points, or if I may, since it's fairly short, I'll just read a couple points from the resolution. Mr. Chairman, or Mr. Speaker, it wasn't too long ago that we had a congressional delegation visit Guam. And having the opportunity, albeit short, to speak with some members of this delegation who are on a subcommittee, which is a smaller committee of a larger whole, Mr. Speaker, and talking about some of the issues of Guam that can be addressed on the federal level, you know, to my surprise that many of them just had no idea even what Section 30 money was, or what some of the issues were, what war reparations were on Guam. Some individuals that, as I would surmise, are supposed to be working very, very closely with our delegate just have no idea. The very core of this, Mr. Speaker, is to put on the record. Oftentimes, our history is told to us. We won't find it in many books. Up to now, even in 2017, much of our history is still passed on orally. And so, moments like this, where we can take an official position historically relevant to us and submitting that to the body of Congress for posterity and for reference, I think is very important. It's something that could potentially help our delegate to use or refer to other members of Congress to let them know what issues we're having and why using Section 30 money is a huge issue. I'd like to go to refer to page 2, starting on line 9, speaking about what Section 30 money is. Section 30 money is Section 30 of the Organic Act as it's described, which is money due to the people of Guam. Money that's decided in law. They can take it away, sure. But Mr. Speaker, while I believe it is time and it is extremely important, we pay with whatever money we can the beneficiaries and survivors from the conflict, from the war. I still think we should still take every opportunity to find alternative funding, as it was promised to us, because it still blows my mind that after all of this time, all it did was come back and say, you know what, okay, you can pay it with your own money, plus we're going to take 5%. I wish I was a little older back then and clairvoyant, because I would have guessed, hey, we should have just paid it ourselves 30 years ago, to where the survivors could have actually used that money. But here we are now, Mr. Speaker, and the fight continues. Let us not be the only people in the history of the world to be relegated to pay ourselves our own reparations. Let that sink in for a second. The only people in the history of the world to pay ourselves. That would be asking the Chinese to have paid their war reparations after Japan invaded, or Holocaust survivors to pay themselves their own reparations. And so the reason this is here and the reason this was an issue of the Decolonization Commission is because our lack the ability to pursue those reparations ourselves, put that onus and responsibility on the federal government to make it right. And I must warn, Mr. Speaker, I'd be remiss if I didn't warn that once we go down this path and continue down this path and not bring it up as a continuous issue, we are setting a precedent that anytime the federal government owes us something, they're just going to peg the responsibility on Section 30 funds. Whenever they need to pay something that's due to us, they're just going to peg that and say, just use that. Just use that. We don't want to go down that road, Mr. Speaker. We must continuously fight for what is right. We must continuously let them know when we've been trespassed against. So I ask my colleagues, please support this amendment. I know it's not going to change anything. I know the war reparations are set in statute and they're moving forward, and I completely support that. But the position of the people of Guam, where we've been, how we've gotten here, should not just be information that we keep on this island, Mr. Speaker. This is information that needs to sit in the National Archives. So 100 years from now, we know, and nobody's going to tell us what our history is and how we were wronged with this. Thank you, Mr. Speaker.
Thank you very much, Senator. Any other senator wish to be heard on the main motion? On the main motion, Senator Espaldon.
Thank you, Mr. Speaker. Mr. Speaker, I think we all understand the intent of this resolution, which is basically a call to our Congresswoman to seek alternate sources of funding for the war reparations, as opposed to the way it is written into law right now, that the war reparations will come out of the Section 30 monies that was already earmarked for Guam in the first place. The argument, in essence, being that we're paying out of our own pockets our own war reparations. And I have nothing against that. I suppose what I really am perhaps a little concerned about, that if this is a resolution that we're hoping that the Congresswoman would be able to use to convince and to speak to other members in both the House and the Senate in Washington, D.C., that perhaps it should be crafted a little bit better. And again, only because if it's going to come as an official message from this House, then I believe that the wording needs to be a lot clearer, and perhaps, and again, no offense to the drafter, but again, if it's going to be an official perspective of this body, which we then deliver on to the Congresswoman, who then will hopefully use it to convince her colleagues in Congress, then I think we need to make sure that we articulate ourselves better. For example, on page 2, line 17, all the way through, on this whereas clause, all the way to the following page to line 4, if I could just read it, it just sounds a little bit messy. Whereas this central problem overshadows other disconcerting aspects of war reparations as it currently exists, inclusive, but not limited to the vagueness of Section 30 funding thresholds, eligibility of World War II occupation survivors, the lack of compensation of surviving family members of those who would have been eligible, an understanding that atrocities committed during Japanese occupation has caused generational problems for the Chamorro people, the fact that 5% of all war reparations is being paid to an office of the U.S. State Department, and that the administering office conducted no outreach to the community. Well, before I even go further, again, I think that sentence it involves a lot of thoughts at the same time, all in one sentence. I think if we were really to drive home the point that perhaps we should simplify, what I just read is one sentence. And I think that all of us have been, who have gone through the English courses, and I believe everybody here has, right? The overriding tenet is always keep it simple. Keep it simple. This is a long sentence that embodies a lot of various emotions and a lot of different alleged facts and sentiments, and perhaps they should be expressed a lot better, especially if it's coming from this body, and this is going to be an official recognition of what we feel. So let me just continue on this whereas clause. These issues threaten to make out what was intended as a solemn process of recognition and healing.
Point of information, Mr. Speaker. Can the current speaker please let us know where exactly we are at in the resolution that he's reading off the whereas clause so we can follow along?
Yes, I'm sorry. That was page 2, line 17. Again, one sentence took up 1, 2, 3, 4, 5, 6, 7, 8 lines. And that one sentence, as I was expressing earlier, contains a lot of sentiments, contains a lot of alleged facts and whatnot. And they all may be true, but they're not expressed in such a way that would command perhaps attention and focus to each one of those sentiments so that they're driven home as serious and really embody the sentiment of this body. And that's my concern with this resolution. Not so much the intent and what we're trying to achieve and the message that we're trying to send, it's how we send it or how we say it. I've been taught from a very young age, sometimes it's not so much what you say, it's how you say it. And I'm not sure we're saying it as clearly and as succinctly as possible to drive the message home of what we're trying to get across. Again, I have no problem with the sentiment. I just think we have to express it better. Thank you, Mr. Speaker.
Thank you. Any other senators on the main motion? Vice Speaker.
Thank you, Mr. Speaker. I would be remiss if I didn't stand and give my full support of this resolution. I commend the author for his remarks on the floor. I concur, and I believe this is something that that is very crucial to put in writing, to put in history, to make sure that history reflects the sentiment of the people of Guam in this regard. I want to start by commending our Congresswoman for her efforts to get us this war reparations. It's a very, very hard task, and we've seen all of our congressmen and women, and I commend all of them for their efforts. I think they have been all very diligent in this regard, and just faced with a Congress that it's really hard to get justice for Guam. And so I commend her for her success in getting this passed. She shares, I'm reading news articles, and it's very clear that she too shares our concerns. So I'm hoping that this resolution will help her in her continued efforts to find, and I'm quoting here, an alternative funding solution that will hold Guam's treasury harmless. And this is a statement by Congresswoman Berdalio. She continues to say, I share the strong concerns in our community regarding the use of Section 30 funds to pay claims But this was the only way to advance this bill, given House Republican budget rules and strong opposition by Senate conservatives, who objected each time this bill was considered on the Senate floor. And we've heard this, and we've, you know, of course, all credit goes to our Manamko who've actually survived, and all the people of Guam who survived this, and those who've watched family members pass without seeing more reparations, and who have that bitter feeling that they are not eligible now, according to the bill passed by Congress. And so I think that the resolution states very well the issues that the structure of the current war claims, that the issues that our Manamko are faced with, that we all are faced with, and I believe the resolution states very well that while we all agree they are justice, the war claims was a pursuit of justice, that paying for your own war claims will never feel like justice. And there's so many ways in which the people of Guam are denied justice, but this is impossible to reconcile. You know, in contemplating this resolution, I have memories of all those people who testified, and I was very fortunate to be legislative counsel at the time when they had the hearing here on Guam, and I want to thank those men and women who were so brave to come out and give their testimony. And if you watched it or you listened to it, those are recorded and they've been preserved, thankfully. It's hard to imagine. It's really hard to imagine Congress doing anything but what they asked after what they went through. But I do want to specifically thank our speaker, who was a very instrumental part of the panel, and he had to sit there and as part of that panel and listen to the testimony, and of course be part of the committee. I'm sorry, the name is escaping me at this moment, but that together with former Speaker Ampinko, and other representatives who had to go through this testimony and make the findings and give that report to Congress. I think all of our former speakers have been very strong in advocating for war claims, and I thank them, just as I thank all our former congressmen and women. I remember the testimony before we ever had the congressional hearing here on Guam. There was testimony, people would go to Congress and testify, and we will never forget them. Beatrice Elmsley, Tomas Barcinas, they did so much for Guam. They were brave, and they were willing to give their all for justice, for not just themselves, but for all the people of Guam and all the people who have gone through the war. So I would like to read the whereas clause again, that first of all, I want to assure the people of Guam that this resolution in no way, I think, can impact their ability to receive compensation under the current war claims statute. This does not change that statute, and so hopefully, if you are eligible, please get your claims in before the deadline in June. And if you need any help, please come to any senator's office. We are open to help you. I know the Congresswoman's office is open to help you. I know that there is a group that is that the mayor's offices might also have people willing to help you, that there is an event at the University of Guam on December 8th where teachers and students and members of our community are getting together to specifically help anyone who needs help to fill out the war claims applications and to get them notarized and to get them sent in. And so I also urge you, if there's anything that our offices can do, to please let us know. We are open 24/7 to help you get these war claims applications in. And so this resolution specifically in the resolved, it only has 2 resolved clauses. One tells you where it's going to be sent, and the other one, which is really the crux of the resolution, says that Imina 34 na Legislature in Guahan does hereby, on behalf of the people of Guam, request that the Honorable Congresswoman Madeline Z. Berdalio and members of Congress seek an alternate source of funding in the fiscal year 2018 budget for war reparations owed to the Chamorro people of Guam. So it's very narrow. It's asking them to find another funding source. And as the previous speaker mentioned, there is one, so it does not ask them to address all the injustices that we feel from this resolution of war claims, or the non-resolution of war claims, the exclusion from war claims of those who had died, those who had survived the war and then died prior to the enactment of the law by Congress, who are now ineligible. So I just want to read some of the things that really are the perpetuation of that injustice in a whereas clause. So these are all contained in a whereas clause, but I thought the author did a good job of describing them. And so I just want to read them into the record one more time, Mr. Speaker, if you would indulge me. Whereas, because I've had lots of people call my office and tell me how they feel, and I think it reflects how they feel. Most of these are manamko and how they feel about certain things, and sometimes they complain about the process, the forms. The forms require you to choose between one of 3 categories. You have to choose a category that you want to be compensated under, and you can't be compensated under all categories. And a lot of time, it narrows their story. And I try to encourage them to make your story as broad as possible so that it's preserved in the record, regardless of whether you can be compensated for all of the parts of your story or not. But the whereas clause states some of these concerns, and it says, this central problem overshadows other disconcerting aspects of war reparations as it currently exists, inclusive but not limited to the vagueness of Section 30 funding thresholds. And we've seen this when we debated during our budget hearings how much Section 30 money would be set aside for war reparations and how much we would actually receive to be able to budget for FY18. Eligibility of World War II occupation survivors, the lack of compensation for surviving family members of those who would have been eligible, and understanding that atrocities committed during Japanese occupation has caused generational problems for the Chamorro people. The fact that 5% of all war reparations, if being paid to an office of the U.S. State Department, that's their fee for administering this program, and that the administering office conducted no outreach to the community. These issues threaten to make what was intended as a solemn process of recognition and healing in an effort to achieve closure into something that cruelly reminds us of our second-class status and the continued colonization of our island. In this way, despite the passage of war reparations, this issue, the decolonization of Guam, and others remain emblematic of the need to change Guam's political status to one where our concerns and our suffrage, both historical and present, are taken serious. Now, this is just a whereas clause, so it's not going to affect what we're asking Congress. We are asking Congress to seek an alternate source of funding. But I just wanted to thank the author for including those things that I think also reflect how those people who are forced to go through this very narrow process, how they are experiencing this process and how it's going to look from a historical perspective. And so I rise in full support of this resolution. Thank you, Mr. Speaker.
Thank you, Senator Nelson.
Thank you, Mr. Speaker. I'd like to thank the sponsor of this resolution and really commend his speech. It was very moving, very succinct, and very accurate. Mr. Speaker, I rise in support of this resolution. And I just want to point out that this resolution is an answer to the Guam World War II Loyalty Recognition Act from the 110th Congress, House of Representatives, Report number 110-129. And it reads, recognition of the suffering of the residents of Guam, the United States recognizes that as described by the Guam War Claims Review Commission, the residents of Guam, on account of their United States nationality, suffered unspeakable harm as a result of the occupation of Guam by Imperial Japanese military during World War II, being subjected to death, rape, severe personal injury, forced labor, forced march, or internment. And then, Mr. Speaker, the most interesting thing about this is there's a dollar value for every instance of suffering that my grandparents, our parents have gone through. I won't be long, Mr. Speaker. Okay. But I just want to share, you know, we've been, when this act was approved by Congress, my office and my team have reached out, and we've been going to the senior citizen centers, and we've been announcing this. And we've been also helping people file their claims. And just the experience of it, you know, and the previous speaker made it very clear. You can only file and receive compensation for one act. So if you're raped, that's the dollar amount you're going to get. If you forced march and you were raped, you're going to get one of the other dollar amounts, which is a clear injustice in the beginning. Because now we're saying the rest of the instances, the rest of the suffering, the rest of the abuse, the rest of the terror that you received during this war, the United States government is always only telling us that we are going to award you in one case. And that is an injustice. Also, the fact that the United States is telling us that we have to use Section 30 funding. You know, it's a huge slap in the face. It shows where we stand in the global scale of this as a territory, which really brings into mind many questions. We are really being treated as second-class citizens. But Mr. Speaker, I want to share that also personally for me, I processed my grandparents' war claim. I processed my aunts, and for them to relive the instances of their, you know, the accounts, them seeing their aunt raped, another seeing their mother raped. To relive that kind of suffering, Mr. Speaker, for a dollar amount is no justice in itself. So I thank the sponsor of the amendment, and I humbly ask for my colleagues' support. Thank you, Mr. Speaker.
Thank you. Any other senator wish to be heard on the resolution? On the resolution? If not, you're welcome to close, Senator Esteves.
Thank you, Mr. Chairman, or Mr. Speaker, my apologies. You know, a lot has been said, and I've stated my case. I'd like to thank the my colleagues in advance for the support that they've shared. A lot of this language was provided again and voted on by the Decolonization Commission. And it was very important that as we format it, we did have to sacrifice some statutory construction and proper English and grammar, I think as a previous colleague has mentioned, to really do our very best to express the same emotion that was provided in the original draft provided to my office. And so, you know, it was painstaking and, you know, could put the T's here, but the focus on that, on the whereas clause, was to express a lot of that emotion that we're feeling and we're getting from a lot of our constituents and from our Manumku people who have gone through this process. And that was important to the resolution in of itself. But truly the only aspect that really matters in regards to everything that's put in there is the resolve clause. And we have a simple ask, is that our delegate continues to seek an alternative funding source as was promised. That's really the question here, Mr. Speaker, is that again, it's when you just break it down to just the simplest of principles. Should the people of Guam be the only people in the history of the world, now and maybe forever, to pay ourselves for what was done to us? Like, that's the core of the issue, Mr. Speaker. And it breaks my heart. And we should never forget what is happening right now. And this shouldn't be brought up 30 years from now. This should be remembered every day. Because every time we forgive an injustice, another one comes around. And my thing, what I believe today, Mr. Speaker, is we remember. Because if we don't remember, we forget. And if there's anything I've seen in all my studies and the people I've talked to, is when we start forgetting, we open the door for other people to tell us what our history is, what the right answer is. Thank you, Mr. Speaker.
Thank you very much. On the motion to send the resolution to the voting file, hearing no objections, so ordered. Colleagues, I'm going to recess until 2 o'clock. We'll vote on the resolution and on 45 at 2 o'clock. And then in the committee room, I will start the hearing on Simon Sanchez. So
I think there's all the bills that are in third reading.
yeah,
right?
there's only 2.
Okay.
And the 3 appointments. Yeah, we voted on the
177?
thing. Okay, but whatever's in third reading, we'll vote at 2 o'clock. So please, everybody be back so we can start the hearing next door. And we'll find all the rest of our colleagues to be here for voting at 2 o'clock. All right, thank you.